Shall we? From '07, reckless driving, suspended license 12, suspended license, assault, VPO, felony continuous, endangering a child, ag assault, reckless driving, now a DWI. And while you're on bond for DWI, you've picked up now evading arrest. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please.
Thank you, Your Honor. On March 30th, 2025, in Harris County, Texas, a law enforcement officer witnessed the defendant recklessly turn and nearly strike the law enforcement officer's vehicle. The law enforcement officer initiated a traffic stop, and the defendant evaded, as the DEM stated, the defendant evaded for 150 yards in the vehicle before being stopped. He couldn't go any further due to a valet parking lot. The defendant then exited his vehicle and fled on foot for 200 feet before being detained by the law enforcement officers.
So he almost hit someone. He's driving.
It looks like he almost hit the law enforcement officer.
So they attempt to pull him over.
Yes, Your Honor.
And he takes off. He gets out of the car and takes off.
Yes, Your Honor.
Did we have a no driving affidavit on this case? Do you know?
No, Judge, but we do have a condition. You don't drive unless you have valid insurance license.
Does he have a valid license?
I'm rerunning it now, Your Honor.
I don't understand. If he doesn't, I don't know how we didn't.
Quick legal note, a no driving affidavit or no driving condition is essentially the court putting a hard stop on someone operating a vehicle while their case is pending. It's the court's way of saying, your driving has become enough of a risk that your privilege to be on the road is being restricted until further notice, and that's important.
How we don't have a no driving affidavit.
Your Honor, I believe this number to be incorrect. It's coming back. The number in here is coming back as eligible average for a different name and shows that whoever had this number was reported deceased. So whatever driver's license number, that's right, Your Honor. I can see the picture now. This is an incorrect driver's license number that I have.
Mr. Estrada, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now revoking your bond on the DWI. It goes with you. I'm now taking you into custody, and I don't know what I need to do to get your attention. Hopefully this is it, but all I want are my streets to be safe. And it's over to the tune of now 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Goes with you.
Your Honor, if I'm able to find a bondsman this morning, would you allow a walkthrough?
No, dudes.
I understand, Judge. Thank you.
Thanks.
It's, this one is going to be on Mr. Zelaya, Kenny Zelaya.
It's because he took off.
Therein lies the dilemma. I am going to ask you for a bond, and yes, I know you are going to say, how do we guarantee that he...
Zelaya. Let me talk to him. I don't mind.
Okay.
It's one FTA.
I know, but
So I'm okay giving it to him. I just want to admonish him that I'm not going to do this again.
he knows his aunt's address.
Are you guys opposed?
Your Honor, I mean, from what I understand,
Tell
So,
what's your...
yeah, we want to give him mental health treatment that he needs. If compliance is a concern, then, maybe a GPS monitor might be a good suggestion.
Okay.
But I think the priority here is to get him into mental health treatment, which we can't do for.
So I'll admonish him that we're not going to play this game again. I'll give you another one. Please go. If you go, good things will happen.
Judge, no objections on, he needs a GPS, just to make sure, if that gets him out so he can go to the appointment at the Harris Center, that'd be great.
Judge, if I may, I believe we can file an order of release and have the Harris Center pick him up from the jail.
Oh, well,
Yeah,
That's jail.
that'd be a more, better solution.
I've never had y'all do that. That's fantastic.
So we can sign a PTI contract. Once that's signed, we can file.
Smells right. It's awful.
Well, Judge will
Yeah. It's not supposed to be fun.
decide, but we'll see what he decides.
The thing is that all we ask you to do is show up. And when you don't show up, this is what happens.
I'm afraid for it.
Why? We're not going to bite you.
Oh, y'all look
Never
fancy.
been to court. How do you know what happens?
Y'all
Oh,
look
man.
too fancy for me.
Come
Not for me,
You really
right?
got stripes like a clown suit. Look at those.
No, yours.
Mine's fancy too.
You're suit up.
So what are you doing with yourself these days? Who are you living with?
Right now, it's staying with friend's house, and then,
Where, do you have mom and dad around?
well, mom passed away when I was 9 years old. So
Hop
and
around?
dad, he's not in the picture. Like, every time I go home, I have problems at home. Like me and him, we fight, fist fight. We just don't like, we can't stand each other.
I want to let you out, but I have to make sure that you're not going to run away. Because when you run away, bad things happen. That's why we put you in jail, because you just didn't come back.
I work at Subway.
This is one of those deeply human courtroom moments. You can feel the judge trying to balance compassion with accountability. On one hand, he may genuinely want to help this person get back on track. On the other, he has to weigh the consequences of the conduct and what it means for public safety. That's the constant tension in criminal court. Because when someone runs, whether from police, from court orders, or from responsibility, it doesn't just affect their own case.
Okay, great. But I still need you to come back. I don't care where you were. You still have to come back.
Okay.
So we can do this the easy way, and then if it doesn't work the easy way, we'll try it the hard way.
Okay,
So-
that'd be great.
What we want to do, the only thing that we want to do is try to have you speak to a doctor, to see how things are going.
Okay.
That's all we would like you to do. And if you do, great things will happen. There's a program that we have where it's called the mental health PTI program, where if you complete it, your case gets dismissed. All you have to do is talk to someone. And if you do that, great things will happen. Can you get that done?
Yes, sir.
Mr. Zelaya, I want you to understand that I'm not going to do this again. I'm giving you another opportunity to do this. If you blow me off again, I'm not going to do this again. You have to understand that no one is going to bond you out. That's why you're stuck there now. You have no one to bond you out. The only way is if you continue to show up. I've given you a lawyer. We're going to give you a cell phone so you can always get a hold of him. Do you have a phone?
Yes.
There's no reason. Do you
I got a
think?
laptop.
Do you think we can get the appointment today so we can give it to him on the way out?
Usually, my understanding was they get the information on the PTI.
Laya.
No, sorry, I was
Oh,
calling.
okay.
Usually they get the information on the PTI sheet that they sign the contract that they're going to do it, and then they go on their own
How long does
accord.
this take?
Oh, and it takes like a month. We usually reset a month, but I thought they call and set up the appointment once they're out.
And
they
let him
go
out for a whole month and waiting and just,
It's not necessarily a full month, it just depends on how long circumstances require it. Sometimes it's a day, sometimes it's a month, obviously it's individualized.
I don't know if I'm going to be down for just letting out for a month while we wait for the appointment to happen.
Well, I think it's on him to call and to go there.
Your Honor, from my understanding of it, if.
That's right.
Once we file, and the CLO might have some, I apologize, never mind. From what
That is what's going on, yes.
I apologize. From what I understand,
No, I think you're right, that we give them the contract, they sign it, and then it's on them to go.
That's my last experience with it, so.
Okay.
Yeah.
Can we get the contract today?
yes, Your Honor. And then once we have the contract, we can file those orders of supervision or release, and we can raise it to Harris Center, and Harris Center will pick him up.
Let's do that.
And then he can go in today, and I
That's
believe,
probably the best course of action.
Harris, pick him up from here, from the
Yes.
county?
yes.
Okay. That's fine. That's, whatever the court wants.
That way we know what
I can do
happens.
that.
Okay, let's do it now.
Okay, cool.
Yes, Your Honor.
So, go ahead.
I'll let you explain it.
No, nothing. It's not about this.
But will you explain to Mr. Zelaya?
I will explain it.
We're working this agreement for you. It's this diversion program that once you have this interview, the case goes away. But you have to get the interview done.
Yes, sir.
It's going to take me at least a day or two. So give me a little bit, but we're working with you to try to get the best thing for you.
Yes, sir.
Okay?
Might be Monday, okay, but you're gonna get out. But you gotta do what's they're gonna do, okay? You got it?
Yes.
Okay.
I trust that you're going to do it.
Yes, sir.
I like your smile.
Thank
You,
you.
you got it sold. All right. All right, Mrs. Zelaya.
Thank you. I'll play across the hall, so you're fine.
What are we doing, Mr. D?
OT must defer adjudication probation, Your Honor. I think it's a good thing for Mr. Gomero.
You've got a bond violation today.
He came back negative, Judge.
Sent him for a test?
Yes, sir, Mrs.
Yes, Judge, I
Felicia
did. It
said.
was negative.
Wonderful.
Yes, sir.
Great. Good job.
Yes, sir. Appreciate it.
That's great. That makes me really happy, Mr. Williams, really. I was upset that you missed the appointment, but you came back, tested negative. That's great. That's
Thank you.
all we're asking, right? You know, because the thing is you're entering into a great deal, right? If you complete this, you don't end up with a conviction. But what you need to understand is that you give up nearly every right known to man by entering into this agreement. And it's a contract between you and the court saying, hey, I'm going to complete this agreement. If you don't, you authorize me to put you in jail for an entire year. So it's no joke. We routinely have to put people in because they just don't get it. We're not asking for much. And I'll make you an even sweeter deal. If you do well and you kick butt, I'll take you off in half the time. If you do your classes quick, don't test positive, be nice to everybody, because you got to understand you're meeting with probation officers. They're dealing with the worst of the worst all day, every day. So if you get in there at 4 o'clock, they're probably going to be in a very bad mood. So make the first appointment in the morning, go in there, crack a joke, be nice. You have the meeting out of your hand, you know?
Sir.
And like anything in life.
This is a significant moment. When a judge signals they may cut supervision time in half if the defendant stays compliant, that's not routine, it's a meaningful incentive. What the judge is really doing here is creating a clear structure of accountability with a built-in reward. Follow the rules, stay out of trouble.
Now, it's a 15-month deferred. Part of the agreement is for you to complete an effective decision-making class, a gun safety class. You must also do a TRAS. This is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them.
Judge, was it 15 months or 14 months?
15.
I have 15. But look, if you do good, you're off in 7.5 months. If you've really, substance abuse treatment as needed, no drugs, no alcohol, no weapons, forfeiture of the weapon, and 32 hours of community service. Is this how you understand it?
Yes,
Did
sir.
you graduate from high school?
I ain't graduate.
No, sir, no.
Oh, no, sir. No, sir. No, sir.
Well, how far did you get in high school?
Last time I was in 10th grade, sir.
Hey, no, it's unacceptable. You need your high school diploma.
Sir.
In lieu of the community service, I'd rather him work to get his GED. You need your GED. If you don't have your high school diploma, every single employer is going to run circles around you. You will make pennies to when other people are making dollars.
Yes,
You
sir.
need your high school diploma.
So
That is my main focus of this thing. Once you get that high school diploma, I'll take you off.
yes, sir.
That's how meaningful it is. You understand?
Sir.
Okay, so what I want is let's set it off 3 weeks. And I want to know within 3 weeks that he's enrolled to start doing classes. Okay? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you are stuck with us until you complete it, or if it gets violated. If you pick up a new case, if you smoke weed, if you do something you're not supposed to do, I'm going to issue a warrant for your arrest. We're going to have a hearing to see if you violated it. And if you did, you're looking at an entire year. But I'm telling you now, I will keep you, and I can keep you for 3 years until you get your high school diploma.
Yes, sir.
We have services so that you can get it for free. So money is never an issue. And I will help you in any way that you need. But that's the most important thing in your life at this very instant. You understand? Okay. How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I'll withhold that. I'm going to waive all your fees. It's never about the money. You understand? If you ever have a problem, you get a probation officer you don't get along with, come here. We can help you out. But don't just take off. It's the worst thing you can do.
Yes, sir.
Good luck, Mr. Camaro.
Thank you, Your Honor. Yes, sir. Thank you, sir.
All right, good morning, Ms. Lee. Ma'am, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Thank you, Judge. On June 16th, 2023, a law enforcement officer conducted an investigation and made contact with the complaining witness. The complaining witness stated she was in the leasing office at an apartment complex when the defendant entered after she was given a criminal trespass warning. The defendant was yelling during business hours while the complaining witness had future residents in the lobby and office. The law enforcement officer issued a written criminal trespass on June 2nd, 2023. The defendant stated she understood the criminal trespass warning at the time. The law enforcement officer attempted to make contact with the defendant who refused to answer the front door, but yelled she was not going to open the door unless the law enforcement officer had a warrant. The defendant was identified by her.
Does she live there?
Yes.
I do not have any facts that demonstrate that in the officer's sworn statement.
Okay, so let's do this. Miss Lee, I'll appoint you a lawyer today so we can get to the bottom of it, and then I can make a ruling a little bit later. What I'll have you do is I'll just have you sign a receipt with Victoria. We'll have you take a seat. Let me appoint you a lawyer, and then we'll have them investigate a little bit further, okay? Please.
Right this way.
Judge, can you sign bond petitions on downbeat?
Yeah.
Simone Lee, because you'd expressed some questions about probable cause in her case,
Correct.
as I have myself.
Okay.
So this is her leasing office. She needs to go in there to access her mailbox, to access, various things. The time that she went in and received a so-called trespass warning was when her car was broken in and she was expressing concerns about it.
My only issue is that a lot of people say it, but they're really not on it. So if you show me that she has like a lease with her name on it at that complex, that would make a huge difference.
She left, but they even say it in the report. There's no dispute on the fact that she lives in there. She was in that leasing office because her car had been broken in. She has text on her phone right now after they gave her the trespass warning for her just trying to sit there while the police come. She would contact them and get authorization from them saying you can come in, just for her to check her own mailbox. So she has text right now on her phone that could show you she lived there, her contact between her and the office.
But I think at this particular moment, I mean, she goes in allegedly huffing and puffing, so they say, hey, get out. Right? And can you read me the DIMS again, State, please?
Yes, sir.
Only.
Looks like on June 16, 2023, the officer conducted an investigation, made contact with the complaining witness. The complaining witness stated she was in the leasing office of the apartment complex when the defendant entered after she was given a criminal trespass warning. The defendant was yelling during business hours while the complaining witness had future residents in the lobby and office. The law enforcement officer issued a written criminal trespass on June 2nd, 2023.
So we know that from June, there's a trespass warning that she can't go. Are you telling me after that she has a text from the leasing office saying that she can't go?
Correct. This is where her mailbox says she has to go in.
Your Honor, from the bench report, it looks like that the defendant came in and caused the disturbance, because her air conditioner was not working.
I'd be huffing and puffing too.
Yes, Your Honor. Apparently, the leasing office sent maintenance personnel to the defendant's apartment to fix the issue, but she refused to allow them inside the apartment.
Well, I don't know. So let's do this. Today's Friday. Let's set it for Monday for a formal hearing. See if you can get some kind of lease, because I'd like to know
Okay.
if she does.
You want me to
Like
come in?
named lease.
Name,
Yeah,
please, and copies of the text messages?
sure.
Okay.
And then let's set it for formal probable cause hearing, because I don't know how you can possibly trespass someone where they live, and then you give them authority, hey, come back. Right?
Yes, Your Honor.
So we'll set it for Monday for a formal probable cause hearing. In the interim, I'm going to order her not to go over there. Come up, Miss Lee,
She's,
until we figure this out. Say that again?
she does not live there anymore, but yeah.
It's probably a good idea. Okay, we're going to set this for a formal probable cause hearing for Monday. Don't go back to this place. Don't have contact with the complaining witness in this case. It's not going to go well if you do. Just don't, and then all will be fine, okay? They're going to create those bond conditions. We'll have to sign it, and then after that, you'll be free to go, and we'll resume back on Monday, okay?
Eric, thank you, Judge.
Thanks. You are Luis Garcia.
Yes, sir.
Mr. Garcia, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Judge. On March 30th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a welfare check on a vehicle and found a vehicle clearly stuck on the right-hand shoulder. On contact with the defendant, the law enforcement officer observed red, glossy eyes and the odor of alcoholic beverage. Defendant admitted to consuming 10 beers at a bar before operating this vehicle. On the Friday test, the law enforcement officer witnessed 6 out of 6 clues in the HDN, 5 out of 8 on the walking tone, and 3 out of 4 on one leg step. Defendant consented to a breath test and blew, I believe this to be an error in the danger runner, but it says 0.016 and 0.0156. I believe it to mean.
Wait, it should be one touch. I don't know. I mean, you can look in the OR, I guess, just to see. Regardless, I think there's enough to go forward. Mr. Garcia, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run his license, please? And does he have any priority to be honest?
Yes, Your Honor. No priority to this, and he is eligible.
Thanks. Mr. Garcia, like I said, I'm finding probable cause. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you to see. If I find that you're consuming, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Do you have the ability to hire a lawyer, sir?
I have one already. I'll hire one. I think she was on Zoom. She's gonna Zoom, Romero's Associates.
Rodriguez, Carlos.
Oh, Carlos. Ms. Broholm, are you here for a case?
Judge, I'm here for the non-disclosure. It's in your queue. I approached you on it on Monday. You said you granted, but we had a filing issue, so I refiled it.
Okay, I'll sign it. But okay.
Thank you, Judge.
Yep. Okay, so I guess let's do this. I'm going to have you sign a reset. I'll have you get with Felicia for your bond condition, then we'll just have you wait for your lawyer to get here. Okay? Don't leave until the. You're Noel Garcia Castillo. Sir, you're charged with driving while intoxicated. Second offense. Looks like they're going to reduce it to a first. However, it's still above a 0.15. So you're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 1 year in jail to be probated for 15 months. As part of this agreement, you will do a repeat offender DWI education class. You will do 2 victim impact panels. You will do, has he done a TRAS yet?
No, sir.
You will do a TRAS. This is an evaluation to see what other conditions you may need. You must fulfill any conditions that they state that you need to do. It could be intensive outpatient, it could be supportive out, whatever it is, you must fulfill those conditions. You must do substance abuse treatment, no drugs, no alcohol. You must have a guardian interlock and perform 20 hours of community service.
Soto?
Do you have children?
Yes.
I would rather do a parenting class instead of this stupid community service that just, you don't learn anything. If that's okay, guys, you know. You must also have restitution in the amount of $1,000. Is it true or untrue that you had a 0.15 or above, sir?
This is the judge's final warning voice. And when a judge says the next mistake carries a minimum of 2 years in prison, that isn't courtroom drama. That's the legal reality laid out in the statute. That distinction matters. Because once a judge puts that warning on the record, the defendant can never later claim they didn't understand the stakes.